Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
All right, let's jump right into a story that sits right at the intersection of, well, groundbreaking technology and the always evolving world of patent law. Today, we're taking a really close look at a legal battle that profoundly shaped how we protect software innovation. We're talking about a fascinating case. It involves databases, big tech giants, and, the very definition of what makes a computer-related invention truly patent eligible.
Absolutely, a really pivotal case.
Our goal today is to cut through all the legal complexities, the jargon, and give you the most important insights from this landmark court decision. So you'll walk away, hopefully not just informed, but with a clearer understanding of how the law really grapples with new technology.
Yeah, it's a constant challenge, isn't it? Adapting law to tech.
Exactly. So to set the stage, let's establish the key players and what was really at stake in this legal showdown.
Absolutely.
Yeah.
So this pivotal case, Enfish, LLC v. Microsoft Corporation, it reached the U.S. Court of Appeals for the Federal Circuit. That's the specialized court that handles patent appeals back in 2016.
Oh.
The opinion itself was authored by Circuit Judge Hughes, sitting with Judges Moore and Taranto.
Okay.
And the specific case number, if you're interested, is 2015-1244. It was an appeal from the Central District of California.
Right.
At its core, this was a dispute between Enfish, LLC, the company that held the patents, and Microsoft Corporation. But they weren't alone. Several other major tech players like Fiserv, Intuit, Sage Software, and Jack Henry & Associates were also defendants appellees.
Wow. Quite a lineup against Enfish.
Yes, definitely. You had Ryan Arman and others from Cooley LLP representing Enfish, and then Chad Campbell from Perkins Coie representing all the defendants, with some additional specific counsel for the different companies involved. A lot of legal firepower.
Clearly high stakes.
And the heart of the matter were Enfish's patents, specifically U.S. patents 6,151,604 and 6,163,775. These actually date back quite a way to 1995.
Oh, interesting. Pre-dot-com boom, really.
Exactly. And these patents described an innovative logical model for a computer database, basically a whole new way to organize and manage digital information. And it was built around this unique self-referential property. Think of it like a smarter, much more flexible digital filing system than, well, anything that was really available before.
A smarter filing system. That sounds promising. So tell us, what was so innovative about this particular database, and how did it end up sparking such a major lawsuit? This is where it gets really interesting for anyone following tech innovation.
Right. Well, Enfish had actually developed and sold software products based on this database model through the late 1990s and into the early 2000s. The patents described a logical model where, unlike the conventional relational databases, the kind that use separate tables for different data types, like one for customers and another for orders.
Yeah, the standard way.
The standard way, exactly. Enfish stored all data entities in a single table. But here's the truly inventive part, the core idea. The definitions of the columns themselves were provided by rows within that very same table. That's the self-referential property.
Okay, hang on. So the table defines itself in a way.
Precisely.
Yeah.
Let's try an analogy to make it clearer for you. Imagine a traditional library, right? It's got separate card catalogs for books, authors, genres. To find a specific book, you might need to jump between these different catalogs, cross-reference them.
Sure, makes sense.
Enfish's innovation, though, was kind of like combining all those separate catalogs into one massive intelligent catalog. And even more impressively, if you want to add a new category to describe a book's, say, date published or maybe reader rating, you wouldn't need to rebuild the whole system. You'd simply add a new entry, a new row within that single catalog that defines this new category, and boom, suddenly all books could be described by it. On the fly.
It does sound much more flexible.
It offered several pretty profound advantages according to the patents. Things like faster data searching, much more efficient storage, especially for diverse data types like images or, unstructured text, and just incredible flexibility, allowing these on-the-fly changes without needing extensive pre-planning or remodeling.
So these weren't just minor tweaks then?
No, no. Enfish argued these were fundamental improvements to how a computer could actually manage information. Not just the information itself, but the process of managing it.
Okay, so they have this tech. Then what leads to the lawsuit in 2012?
Right. Fast forward to 2012, and Enfish sued Microsoft. They allege that Microsoft's 8.0.NET product, which is a framework that helps software developers manage database data, infringed their patents by essentially creating and manipulating these self-referential tables.
Ah, so Microsoft was using their idea, according to Enfish.
That was the claim. Now, the district court, the first court to hear the case, initially sided with Microsoft on several key points. They ruled that all of Enfish's asserted claims were invalid under 35 U.S.C. Section 101.
Okay, and Section 101 is about.
That's the big one. It determines what kinds of inventions are even eligible for a patent in the first place. The district court basically said Enfish's claims were directed to an abstract idea.
Abstract idea. That sounds bad for a patent.
It is. The court felt Enfish was trying to patent a concept, like just organizing information, rather than a concrete technological invention. And on top of that, some specific claims, 31 and 32, were also found invalid under Section 102B.
Section 102.
That deals with novelty and anticipation. The court said those claims were anticipated by Microsoft's earlier Excel 5.0 product, essentially saying Enfish's idea wasn't actually new because Excel already did something similar. And finally, they found Claim 17 wasn't infringed by 8.0.NET anyway.
Ouch. So a pretty rough initial outcome for Enfish.
Definitely. So as you can imagine, Enfish promptly appealed all of these findings to the Federal Circuit.
Okay, so after those initial rulings, what were the critical legal questions the Court of Appeals for the Federal Circuit really needed to tackle, and how did each side lay out their case?
Right, the appeals court faced three really central questions, and these would have pretty significant implications for software patents moving forward. First, the big one. Were Enfish's claims truly an abstract idea and therefore ineligible for a patent under Section 101, as the district court found?
Okay.
Second, were Enfish's claims actually anticipated, basically not new, because of Microsoft Excel 5.0's pivot table feature? That's the Section 102 question.
Got it.
And third, did Microsoft's 8.0.NET product genuinely infringe Enfish's Claim 17? The infringement question. Microsoft also tried an alternative argument that Claim 17 was indefinite, but the court didn't really bite on that one.
All right, let's hear Enfish's side first. What were their main arguments trying to overturn those earlier decisions?
Well, Enfish argued, quite forcefully, that their claims were not an abstract idea at all. They framed it as a specific improvement in computer functionality. They really insisted that their self-referential table design was a concrete technological advancement, not just some general concept for organizing information.
They were saying, this makes computers work better.
It's exactly. This is a technological solution to a technological problem. On the anticipation point regarding Excel 5.0, Enfish maintained that pivot tables just didn't anticipate their invention. Their patents, they argued, specifically required the column definition to reside within the same logical table.
The self-referential part again?
Yes. They contended Excel's approach, which used, separate raw data tables and pivot tables, just didn't meet that precise requirement. And regarding infringement, Enfish challenged the lower court's interpretation of a key element in their patent Claim 17, something called a means for indexing, arguing that 8.0.NET did, in fact, perform the equivalent function, even if slightly differently.
Okay, so that's Enfish's position. What about Microsoft's counter-arguments? How did they defend the district court's initial rulings?
Microsoft naturally doubled down on the district court's findings. They kept asserting that Enfish's claims were simply directed to the abstract idea of organizing information using tabular formats, which they believed just wasn't patentable subject matter.
Just arranging data.
Right. Too conceptual. They also argued that Excel 5.0's pivot table feature did anticipate Enfish's innovation. They pointed out how a value from a raw data row could effectively become a column in a pivot table, sort of mirroring, in their view, Enfish's self-referential concept.
A functional similarity, maybe?
That was their angle. And on the infringement front, Microsoft argued 8.0.NET lacked specific structural elements required by Enfish's means for indexing claim, especially regarding how it stored keyword values and handled pointers within its index structure. They said, our tech just doesn't work the way their patent describes.
Okay, so after all that back and forth, the Federal Circuit had to weigh these complex arguments. What was their ultimate decision? Where did they land?
Well, the Federal Circuit delivered a really interesting mixed verdict. It was a bit of a split decision, you could say.
How so?
First, they reversed the district court's decision on patent eligibility under Section 101. They concluded that all 5 claims Enfish appealed are patent eligible.
Wow. That's huge for Enfish.
Massive win for Enfish on the most fundamental question. Then, they also vacated the district court's ruling that claims 31 and 32 were anticipated by Excel 5.0, basically saying, no, those claims were not anticipated.
Another win. So far, so good for them.
Right. However, they affirmed the district court's finding of non-infringement regarding Claim 17. They agree that ADO.net does not infringe that specific claim.
Ah, okay. So a win on eligibility, a win on novelty for those claims, but a loss on infringement for that specific claim.
Exactly. So the entire case was then sent back or remanded to the district court for further proceedings, but now guided by these new rulings from the Federal Circuit.
Wow, so a really nuanced outcome. Let's dig into the court's reasoning behind these crucial decisions, especially that big win for Enfish on patent eligibility. That seems like the most significant part. What was the court's core logic there?
Yes. This is really the most insightful part of the decision for anyone trying to understand software patents post-Alice. On that Section 101 patent eligibility question, the court directly applied the Supreme Court's Alice test. Remember, that's the 2-step test.
Right. Step 1, abstract idea. Step 2, inventive concept.
Precisely. And the Federal Circuit found that Enfish's claims were not directed to an abstract idea at Step 1, which meant they didn't even need to go to Step 2.
I stopped right there. Why?
The key distinction the court made, and this is crucial, was their emphasis that Enfish's claims were directed to a specific improvement to the way computers operate. It was embodied in that self-referential table structure.
An improvement in the computer, not just using the computer.
Exactly. They explicitly differentiated this from claims that merely use a generic computer as a tool to perform a well-known abstract idea, like the intermediate settlement claims in the Alice case itself, or pricing calculations in another case called Versata. This is a vital clarification. It's not just any use of a computer, but an improvement to the computer's functionality itself that could be patent eligible.
And the benefits mattered.
Yes, the court specifically noted that the patent taught concrete benefits over conventional databases, things like increased flexibility, faster search times, smaller memory requirements. These weren't just abstract goals. They were tangible technological improvements linked directly to the claimed structure.
That makes sense.
And what's particularly important, especially for software innovators listening, is that the court firmly stated that software claims are not inherently abstract. They acknowledge that much of computer technology advancement comes from software, and these innovations shouldn't be automatically excluded from patentability just because they aren't, physical in the traditional sense.
That must have been a huge relief for the software industry.
Oh, absolutely. There was a lot of uncertainty after Alice, a real fear that maybe most software wouldn't be patentable anymore. Enfish pushed back against that.
That really does sound like a game changer for software patents. Okay, now let's switch gears slightly. What about the anticipation argument? Why did the court say Microsoft Excel 5.0 didn't anticipate Enfish's claims?
Right, this came down to very precise claim construction, basically, interpreting the exact words of the patent claim. Enfish's claims, especially Claim 31, required a logical table where at least one of its logical rows has an OID that's an object identifier, like a unique ID, equal to the OID of a corresponding one of its logical columns. And crucially, that row includes column information defining the columns. The key part was that this self-referential property had to occur within the same logical table.
Back to that same table idea.
Exactly. The court looked at Excel 5.0's pivot table feature. Yes, it linked data, but Microsoft's argument relied on connecting a row in their raw data table to a column in a separate pivot table.
Two different tables.
Two different tables. And the court was very clear on this. They said, and I'm paraphrasing slightly, fundamentally having a row in one table reference a column in another table is not a self-referential table at all, but something more like referential tables, or tables that refer to one another.
Ah, a critical distinction in terminology reflecting the structure.
Precisely. Even if both appeared visually on the same spreadsheet, logically, in the court's view, they remain two distinct tables. Because of that specific structural difference, Excel 5.0 did not anticipate Enfish's claims. Enfish's invention was still novel in that specific regard.
That's a subtle but clearly very significant legal distinction. Okay, finally, let's tackle the infringement part. Why did Microsoft's ADO.NET product not infringe Enfish's Claim 17?
Okay, so this specific claim, Claim 17, used what's called means plus function language. Instead of describing a specific structure, the patent described a function, in this case means for indexing, and then referred to the specification for the structure that performs that function.
Right, so you look at the patent details to see how it does the indexing.
Exactly. And when a patent uses this language, the claim is interpreted to cover the specific structure, material, or acts described in the patent's detailed specification for performing that function and equivalence to that structure.
Okay.
Now, the district court had accepted Enfish's own proposed three-step algorithm for how this means for indexing worked. The Federal Circuit agreed with this interpretation, including a requirement for specific things like bidirectional pointers mentioned in the specification.
So they established what Enfish's means for indexing actually entailed structurally.
Correct. Then they looked at Microsoft's AD.NET, and they found substantial differences. For instance, ADO.NET didn't perform step 2 of Enfish's described algorithm. It stored references to text values in its index, not the actual text values themselves.
A different way of pointing to the data.
Kind of, yes. And for step 3, it didn't store direct pointers from those text values back to the index. Instead, it used pointers to other objects that might eventually resolve back to the index, but indirectly.
So not the same steps, not the same structure.
Right. These weren't considered minor variations. The court deemed them substantial differences. Because ADO.NET's indexing algorithm was neither identical nor legally equivalent to Enfish's patented one, the court affirmed the non-infringement finding. Microsoft's product just didn't operate in the way Claim 17 required.
This has truly helped clarify some really complex patent law principles. It's fascinating how specific the analysis gets. What precedents and statutes did the court lean on to make these nuanced distinctions? And stepping back, why is this decision so incredibly significant for, well, anyone interested in the future of technology?
Well, the court relied heavily on the core statutory provisions governing patents here in the U.S. That's Title 35 of the U.S. Code. Specifically, 35 U.S.C., Section 101 for patent eligibility, Section 102 for anticipation or novelty, and Section 112, Paragraph 6 for interpreting those means plus function claims we just talked about.
The basic building blocks of patent law.
Exactly. And for Section 101, the eligibility question, they very carefully navigated the big Supreme Court precedents, particularly Alice Corp v. CLS Bank International and Mayo Collaborative Services v. Prometheus Laboratories. Those cases established that two-step framework for evaluating abstract ideas that we discussed.
Right, the Alice Mayo framework.
And they also cited and distinguished Enfish from previous Federal Circuit cases, like OIP Technologies or Fershada, where software claims had been found to be merely abstract. They were drawing lines in the sand, essentially.
Okay, so how does that make Enfish itself so significant?
What's really fascinating here, and why we're talking about it, is that Enfish v. Microsoft became a landmark decision, because it provided much-needed clarity for software patent eligibility after the Alice ruling threw things into uncertainty.
It calmed the waters a bit.
It really did. Before Enfish, there was a genuine, palpable concern in the tech industry that the Alice ruling might be interpreted so broadly as to render nearly all software patents ineligible, which could seriously chill innovation. This case decisively pushed back against that broad interpretation.
By creating that improvement in computer functionality standard.
Precisely. It established that claims directed to an improvement in computer functionality itself are not abstract ideas under Step 1 of Alice. It carved out a clearer pathway, emphasizing that if your software invention makes the computer work better in a fundamental technological way, it has a much stronger chance at patent protection. It wasn't just about automating a known process, it was about improving the tool itself.
So it protects and encourages real technological progress in software.
That's the key significance, yes. It helps answer that question. How do we encourage true software innovation while still preventing people from patenting, just abstract concepts or basic economic practices done on a computer? Enfish provided a clearer test. So if you take just one single thing away from our discussion today, it really should be this. The Enfish decision is a critical precedent because it affirmed that software inventions can be patent eligible under 35 U.S.C. Section 101, specifically when they genuinely improve computer functionality itself, rather than just implementing an abstract idea on a generic computer. It drew a vital line. stopping a potential wholesale rejection of software patents and offering a much clearer path forward for inventors in this incredibly important space.
What an incredible discussion. We've really gone deep into the intricacies of patent law and software innovation here. It's amazing how one, clever design for a database can spark a legal battle that not only clarifies, but really helps define the boundaries of what can even be patented in our increasingly digital world.
The ripple effects are huge.
Yeah, this ruling powerfully emphasizes that innovation isn't just about physical machines anymore. It's also crucially about how we make those machines smarter, faster, more capable through software.
Absolutely fundamental to modern tech.
So as you, our listener, consider all this, think about the technologies you interact with every single day, from the apps on your phone to the incredibly complex systems running global businesses. How many of those are built on innovations that might not look physical, but fundamentally improve how computers actually operate?
It's almost everything these days.
It really is. And how does the legal protection of those innovations, or maybe the lack thereof, encourage or perhaps even stifle the next big breakthrough? This case, Enfish, gives us a really powerful lens through which to view that ongoing tension between law, technology, and progress. Thank you so much for joining us on the Deep Dive.